Support comes from Mosby Building Arts. This year, put your trust in Mosby Building Arts for fresh designs and the elevated remodeling experience you deserve. Inspiration at callmosby.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. Republican lawmakers are coming after the Missouri Supreme Court. One accuses the judges of acting like, quote, little kings and queens in their black robes. What has them so riled up? And a developer is suing local leaders in St. Charles County after they blocked his plans. Could they be on the hook for a fat payout? And a man in St. Louis County snapped and started shooting at strangers at Applebee's. Is it murder or is it involuntary manslaughter? These are big questions, and today we have three top lawyers joining us to lend their expertise and help us get answers. Yes, today is our legal roundtable, and today that includes Sarah Swadesh. She's a labor and employment attorney. She is in private practice at the law office of Sarah Swadesh. Sarah, welcome back.
Thanks so much.
And also a rare treat. Today we're joined by Kalila Jackson, a senior staff attorney with Equity Legal Services, Inc. Kalila, we are so glad we got you back.
Nice to see you again, Sarah.
And last but never least, Bill Freivogel. He's an attorney and a professor at the School of Journalism at Southern Illinois University, Carbondale. He is one of the founding panelists of this legal roundtable. We have one of the OGs in the house. Bill, welcome back.
Hi.
So in just a few minutes here, we'll talk about the developers that are suing government officials for blocking their plans. And we'll talk about that tragic shooting at Applebee's and how that falls under criminal law. But before we dive into either, there was some big news this week on the judicial front. The Missouri Supreme Court is under fire from some Republican lawmakers. Chief Justice Brent Powell did not give his State of the Judiciary speech. It had been planned for Wednesday on the House floor. One lawyer accused him of presiding over a, quote, runaway court. Others talked about judicial overreach. Bill, we hear a lot about clashes between the judicial branch and the executive one. This seems to be happening on the federal level. But here we're talking legislators in Missouri. This seems to have caught a lot of people off guard. What got these lawmakers so wound up?
Well, that they lost what they lost in the Missouri Supreme Court.
They lost a case.
They don't seem to be talking about how mad they are at the Missouri Supreme Court when it get unanimous opinion upholding their transgender care ban. But where the Supreme Court doesn't agree with the way they want to take over the control of the language on initiative petitions, they get all upset about that.
I mean, Bill, the way that you describe this, the language on initiative petitions, this is not like one of these hot button issues that we generally see the culture war being fought over.
Well, except that the initiative petitions often are about the cultural war issues. Abortion, for example. I mean, abortion is the issue behind, one of the issues behind this particular
this case that they lost.
Yes, right.
Sarah, can you break this case down for us? What everyone is so mad about this. What is this case even about? It's about rewriting the language that goes on the ballot.
Yeah, sure. So it was a ballot. The legislature wanted to change how ballot petitions were finalized, and so what happens is the petitioners suggest language that they want to ballot, and the Secretary of State has the authority to rewrite that language. And what happened is the Secretary of State submitted language, the Missouri Supreme Court rejected the language, and it went back to the state. I think the judge rewrote the language, and so this new law that they were trying to pass was Senate Bill 22, said that the judiciary no longer gets to rewrite the ballot language. If the ballot language is rejected, then it goes back to the Secretary of State to rewrite it, and the Secretary of State gets 3 chances to rewrite the language. And opponents to Senate Bill 22 said, no, all you're doing is slowing down our referendum, so we can't get the ballot in front of the voters. All you're doing is slowing it down. You're not really trying to fix it. You're just trying to gum up the system.
The Secretary of State could just keep coming back at it. Here's my other bad faith attempt to rewrite this over and over.
And it never gets finalized, never gets before the voters. But the reason it got shot down by the Missouri Supreme Court is because in this law, Senate Bill 22, the legislators snuck in a provision about the attorney general getting to direct appeal any issue they lost. So no preliminary injunctions. Usually preliminary injunctions are final until the matter gets all the way up to the Court of Appeals or Supreme Court. Well, in this case, they don't want to, the attorney general doesn't want to wait. If he loses, he wants to appeal immediately.
So he'd get like that fast pass. I think you described it on a previous show.
Yeah. And so this Senate Bill 22 had the ballot language issue, and it had the attorney general fast track issue. And the Supreme Court said, no. We have in our Constitution original purpose, meaning you have to stick to the original purpose. You can't omnibus these things, these issues. And by sticking the attorney general fast pass issue in this bill, you've defeated the bill.
So, Kalila, it sounds like, based on Sarah's summary here, that if this was something that these lawmakers were really wound up about, they could come back and just have a single topic bill and say, okay, we want the Secretary of State to be able to rewrite these things, and have that then try to stand on its own to see what the court said about that.
Yeah, and I think that point's been made a couple of times. The judiciary has pointed out that, they've gotten slapped on the hand a few times for continuing to try to push these things through in big omnibus bills. And so I think what we've seen, and we'll talk about it later, is a reaction to that. The courts have said there's a way to do it. The leader has even acknowledged that there's a better way to do this, but we keep seeing this pop up.
So these lawmakers keep trying to do this. The court has struck this down. This led to what happened this week when he was supposed to give. The chief judge of the Supreme Court was supposed to give this address to like a joint chamber. And then we keep hearing, oh, this has been canceled. Now the court is saying it hasn't been canceled. The language that public radio has ended up on is it was scuttled. It didn't happen. To me, it didn't happen. Somebody canceled it.
Well, these speeches by the Chief Justice, who actually also wrote the opinion that they were mad about, for a unanimous court. These speeches are always to a joint session of the Missouri General Assembly, and enough senators and other representatives were mad about it that they weren't going to have enough people for a joint session, and so
kind of the lawmakers canceled it by canceling the joint session?
Yeah,
okay.
I'd say that's correct.
But the Chief Justice still was like, yeah, I'm not just going to speak to the Democrats who show up, which maybe could have been an option. Sarah, would you have done that if you were the Chief Justice?
I probably would have scuttled it as well.
Interesting. Kalila, what about you?
Yeah, I think that there are certain protocols that, judges, particularly chief justices, there are procedures, there are protocols, and they tend to stick pretty tightly to that. And so if that joint session wasn't going to happen, I can completely understand why Chief Justice Powell decided that it couldn't go forward, to the extent that that is what happened.
Yeah. He didn't want to speak to a room of just Democrats, and that might not be a good look at a time when clearly the judiciary in Missouri is now under attack by some Republicans.
Well, right. In the wake of this, of the cancellation, and in the wake of the Supreme Court decision against their ballot proposition bill, a number of the Republican legislators are talking about how we need to get rid of the nonpartisan court plan. Missouri is famous around the country for it's called the Missouri Plan some places. Which is a process that in particularly in the big cities moves the selection, and for the Supreme Court moves the selection from election by the people to this nonpartisan selection where there's a body that includes 3 citizens, 3 lawyers appointed by the Missouri Bar, and the Chief Justice, and who recommend people for these various judicial positions. In a lot of parts of Missouri, it's still elected. Yeah. The judges are still elected.
For the circuit courts.
For the circuit courts, right. And this has been about 38 states have adopted the Missouri Plan and moved away from election of judges. But from time to time, this becomes a hot button issue. I remember about 10 or 15 years ago, there was a move by Republicans to impeach Rick Titleman, who is a rather liberal judge on the Missouri Supreme Court. And that got into discussion of we don't need this nonpartisan court plan, and attempts to change it, but that were rejected by the people.
It's interesting. I am from Ohio, Cleveland, and we elect judges, Supreme Court judges there, and it is a crazy thing. It is $1 million being spent on these campaigns. Law firms donating huge sums of money to try to elect one candidate over another. And then you kind of have this concern when you see how a judge rules after $1 million has fueled their campaign. You get suspicious. You wonder if the money talked. It seemed like a very broken system that I grew up within.
And that's happened closer to home in Illinois, there where the judges are elected. And there have been really big, expensive, multi-million-dollar campaigns where on one side you have State Farm and big business, and the other side labor unions and the trial lawyers duking it out. And it's resulted in those elections have sometimes resulted in some eventual decisions by the Illinois Supreme Court that were then questioned as being, was this a decision that resulted from the influence of multi-million-dollar campaign contributions in elections?
For lawyers who are there practicing in these courts, do you like this Missouri plan? Do you want your judges coming through this system, or would you rather see a more direct democracy?
I like the Missouri plan personally. So, as you said, the judges in the rural counties are elected, but it's St. Louis City, St. Louis County, Jackson County, and the Court of Appeals that go through this Missouri plan. It's 3 citizens, 3 lawyers, judges. They narrow the panel to 3 people, and then the governor picks among the 3. And so it is a much more neutral process than throwing money at election campaigns. Plus, after every 7 to 10 years, there's an up or down vote by the citizens. So if the citizens don't like what a judge is doing, they can vote the judge out. And so it's not in a lifetime appointment like a federal judge. The citizens do have control over whether to keep a judge. And I think the direct election is not the best way to go about it, because I do think there will be a ton of money coming in from out of state, a ton of corporate money coming in influencing judicial picks.
Kalila, I wonder if you share that perspective.
Yes, I am a proponent of the Missouri plan, but recognizing that it has limitations, particularly as it has for opportunities for people of color, and of course, money influences comes into every situation. But overall, to Sarah's point, the fact that it keeps some of the dark money out of our judiciary. The fact that you have that opportunity for citizens to have that say at some point. I do believe that the Missouri plan, should stay. And I don't think that we should even. I heard Bill say that this is something that has been brought up before, but you cannot take for granted that the party that's raising this, the Republican Party, has a supermajority. And they have proven to be, when they dig in on issues, they've been very successful. And so I think that if you are a proponent of the Missouri plan, if you believe in having a balanced judiciary, it's important to pay attention to this issue and not take for granted that this is something that just because it was created here and has been so foundational that it will stay that way.
For those of you who are listening, you may have a question for our panel about how the judicial system works here, how this Missouri plan works. Our phone lines are open. We're at 314-382-8255. That's 314-382-TALK. Sarah, you were going to jump in there.
Yeah, so the Missouri plan was created to combat the mob boss in Kansas City, Tom Pendergrass, and it has proven to be very successful. In fact, in the Missouri Supreme Court, there's a commemorative statute acknowledging how successful the Missouri plan has been. And if we talk about electing electing judges, maybe we elect rural judges or Missouri Supreme Court judges. Maybe it feels like a big deal to some people, not a big deal to other people. Imagine on the grander scheme if we start electing U.S. Supreme Court judges, right? If your stomach churns at the idea of electing a U.S. Supreme Court judge, your stomach should equally churn at electing a Missouri Supreme Court judge.
The Missouri General Assembly has tried before to get rid of the nonpartisan court plan. As Sarah said, it was adopted because of Boss Pendergast. But in 1942, the General Assembly referred to the voters to eliminate it, and the voters said no.
Yeah. Even if it doesn't work for the people whose laws are being struck down, the voters are like, yeah, we kind of like this system. But man, some of these comments coming from these lawmakers, I have to give the Post-Dispatch credit. They had a really good story with some quotes where I was like, whoa. Rick Bratton, this is a Republican from Harrisonville, he said the court had, quote, flagrantly thrown the Constitution into the mud and flips the middle bird to us every freaking day. I'm highly upset that they would cancel because their butts needed to be sitting over in this chamber while they see everybody stare at them in their face for the crap they pull. Instead, they get to hide behind their little brick building like little kings and queens in their black robes. I saw the Missouri Bar Association made a statement pushing back on this. I'm wondering if this is something that ordinary lawyers, are you guys concerned by this language and sort of just this tone we're seeing of attacking the state Supreme Court?
I think it's emblematic of the state of political discourse in the United States in general, and it is unproductive, and it is not healthy, and there is still a level of respect that you think that would be shown to the highest officer of the judiciary in this state, and that statement just it really is polarizing. And what purpose does it serve?
Sarah, are lawyers, just rank and file lawyers, not people who want to be judges, are they concerned about this?
I think absolutely. Yeah, I mean, I think we all, most of us went to law school learning about the Missouri plan. I think most lawyers would tell you that it works, it works. And I can't imagine any lawyer or many lawyers in St. Louis City County, Jackson County, who would want to go to elections. The amount of money that would have to be raised, the amount of just grinning and smiling and campaigning. I don't think lawyers want it. I think lawyers want to be lawyers, and they want people who they believe are genuinely impartial. You may have been appointed by a Republican governor, but it doesn't mean you're bought. It just might mean you're conservative. Whereas now you're getting campaign dollars from, State Farm, or you're getting campaign dollars from the ACLU, it's starting to feel more bias.
And 5 of the 7 judges on the current court were appointed by Republican governors.
Isn't that interesting?
It is.
We're talking today to our legal roundtable. That is attorney Bill Freivogel. We're also joined by Sarah Swadesh and Kalila Jackson. We need to take a quick break. When we come back, we're going to talk about a couple of other matters that the Supreme Court is digging into, including that one on gender-affirming care and an abortion case that is likely headed right back up to them. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our legal roundtable. Always one day sort of near the end of the month, we convene some of the top lawyers in town, and they help us understand what's been going on in the news and how the judicial system interacts with all of our lives. Today, we're joined by Kalila Jackson, a senior staff attorney with Equity Legal Services, Inc. We're also joined by Bill Freivogel, an attorney and professor for the School of Journalism at Southern Illinois University, Carbondale, and also Sarah Swadish, a labor and employment attorney who's in private practice at the law office of Sarah Swadish. So, Sarah, Bill had mentioned the court did have this big ruling on gender-affirming care. And this is something that I believe this was also a unanimous verdict. They ruled in a way that you would think Republicans would be dancing. We won this one. The court is on our side. Instead, they're very angry at the court about something else. They're also likely to be eventually making a ruling that decides what kind of restrictions we have on abortion. That's something that was the subject of a trial in Jackson County court these past weeks. It's interesting as the court is sort of looking at this. They're ruling on gender-affirming care. They didn't seem to be really looking at the merits the way that somebody like me might think of this as the merits. Talk to us about sort of what standard ends up being crucial here.
Sure. So the lawsuit was brought on behalf of 3 minors seeking gender-affirming care. And the minors were essentially claiming that this is unconstitutional. And so when we say, is it unconstitutional, what we're really saying is, does this cross a line? Is the government allowed to take this action? Does it violate my rights? And when that question is posed, there are 3 types of review that the court will give it. The first is called rational review. And what it really means is, does the law make some sense? And if it does, it will stand. And then the second review is the intermediate review. And the standard is, well, does the law serve a meaningful, important goal? And it really means, is there a real reason, not just an excuse? And then the last sort of review is called strict scrutiny. And that means you better have a damn good reason and you better prove it. And it also has to be like the only way to achieve this goal. And so rational review is applied to like economic regulations. Strict scrutiny is applied to anything tied to like race or fundamental rights. Mm-hmm. And so the court started with, this is a constitutional challenge, but what review does it fall under? And they said it doesn't fall under strict scrutiny because transgendered doesn't have to do with race. It's not a protected class. They said it really has to do with healthcare regulations. And under Dobbs, healthcare regulations are not a protected class. It's not a fundamental right. It's more of a economic regulation, a medical regulation. And since it's a medical regulation, not a fundamental right that's being infringed, we're going to give it rational review. And rational review says if the law makes some sense, it will stand.
I think you'd hear maybe, I don't know, a lot of people under the age of 50 who would hear that and go, what? Like sexual identity for a lot of people is this fundamental thing. It's not just this economic standard.
Well, I think you're hitting on something, right? And so what the court deems a fundamental right really is what dictated the scrutiny level. So by rejecting the claim, because of course that's what the plaintiffs were arguing, that this is absolutely at the essence of what these children, about what the transgender community, and the court in essence rejected or erased that as the defining identity. And so that, while it is not directly on the merits, it does speak to it. And so it's a part of a concerning pattern that's playing out across the United States. And many places in the wake of the Supreme Court decision are grappling with this new reality and defining. And it's really a question of who gets to define what is a fundamental right. And in this case, by classifying it as more of a healthcare concern, or I think the language that they used is that there is no fundamental right to seek care prohibited by the legislature. And so by narrowing down the question, taking it very far from what the plaintiffs. It changes the analysis,
and I think they got there from the Dobbs decision, which overturned Roe v. Wade, because the Dobbs decision says it's a fundamental right if it's deeply rooted in our history, and abortion isn't deeply rooted in our history, and so it's not a fundamental right. And the Supreme Court built on this by saying medical care, autonomy over your body, abortion, medical decisions is not a deeply historical, it's not based on deeply U.S. historical meaning, and therefore it's not a fundamental right. And so they built off Dobbs.
The standards of review that Sarah explained so well, I mean, that's like a preliminary decision of a court. And if they choose rational basis, that means the statute's going to get through. Yeah. Almost never. I mean, think of them as like hurdles for the law to get over. Rational review, everything passes. Strict scrutiny, almost nothing gets by. Height, the middle level that she described, some gets by and some doesn't.
So it feels like something that for those of us who aren't lawyers, it's like, oh yeah, they're just choosing the standard. But you guys are telling me this is like a fundamental.
It determines what the decision's going to be. But when I saw the rational basis, I mean,
you knew
that's the end of it. This case reminds me a little bit of a much older case where there was the U.S. Supreme Court said that pregnancy was not a gender-based or sex-based status. And it took an act of Congress, literally, and then subsequent Supreme Court decisions to change that.
Yeah, that's
it's a little bit. Missouri Supreme Court reminds me a little bit of that by saying, well, transgender status has nothing to do with sex or gender.
Yeah. So every year I know that people who are advocates for the LGBTQ community go to the Missouri legislature and they try to pass a law that would make it clear that you can't discriminate on the basis of your sexuality, that you couldn't discriminate in housing, you couldn't discriminate in employment. Based on whether you're LGBTQ. Every year that fails in Missouri. And I hear some people say, well, why does it matter? Everybody knows you can't discriminate on those bases. People wouldn't do that because they'd just file a lawsuit. If that was enshrined in state law, would that make a difference in something like this? Because then it would change the standard.
I think at the very least you'd get the intermediate scrutiny then, at the very least, because on the rational review scrutiny, the petitioner, the plaintiff has to come forward and carry the burden of why the law is wrong or why it's infringing. At least on the intermediate scrutiny, the government then has to turn around and say, no, this is a legitimate purpose. This is a compelling reason. So at least if they were enshrined it, there could be a shot at getting this changed.
Sarah, would you agree that they would have to enshrine it in the Constitution, though? Not just in a statute? Which I think is what has been pursued previously.
I don't think so, because, I mean, based on what Powell said, he says if the legislature's created a law and made it illegal, then it's not fundamental. Well, if we have a law that says it's now fundamental, I don't think it would have to be in the Constitution. I think it's now fundamental by statute.
The law would have to be clear that transgender status was
included,
related to discrimination based on gender or sex.
Okay. Well, we're probably just talking about a hypothetical here. It doesn't seem that the Missouri legislature is going to do that anytime soon.
I mean, everything is moving in the other direction. Yeah. I mean, this Missouri Supreme Court case is in line with the U.S. Supreme Court case of, I guess, a year ago, where they upheld a similar kind of ban in Tennessee. And this Missouri Supreme Court case quotes from that U.S. So they're not out of line.
Yeah, and the Eighth Circuit just affirmed a ban for Arkansas as well in the federal court. So we may not like it, but it is consistent.
But I think that this is a marked departure. The Supreme Court has reversed decades of jurisprudence in order to reach these results. And
with Dobbs, you mean?
With Dobbs. And so I remind the audience that courts get it wrong. And courts can get it wrong for hundreds of years. And I'm always reminded, it's never lost on me about the Dred Scott decision that was decided right here in the old courthouse. And so just because a court because unfortunately courts are a product of the zeitgeist. They are a product of the people that produce them, and they get it wrong.
And what's fascinating here is in our first segment, we were really sort of defending the Missouri Supreme Court against this kind of attack coming out of the legislature. At the same time, you're acknowledging that in many cases they do get it wrong. You think they may be getting it wrong here is kind of how I'm reading what you're saying as well.
Yeah, I think they got it wrong.
Yeah.
But I think that it's part of this is where the courts are headed right now. And so for people who consider themselves, I consider myself to be a civil rights practitioner, consider myself to be a civil rights lawyer, these decisions are disturbing. But that doesn't mean that there is a way to handle the disagreement. There's a way to have the discourse. And what we're seeing play out in the Missouri General Assembly, that is not the appropriate way to handle a dispute with the judiciary.
But the fact that you had a majority of a unanimous majority of the Missouri Supreme Court angering liberals with the transgender case, and then the same court angering the conservatives with the ballot proposition just shows how off-base the Republican criticism is about them being a runaway court, just ignoring the Constitution. I mean, this is what the Constitution said in each case.
We're talking today to our legal roundtable. That's attorney Bill Freivogel. We're also joined by Sarah Swadish and Kalila Jackson. We're going to take a short break here. When we come back, we're going to talk about a developer suing elected officials who blocked his project. What are the chances he could succeed? This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fensky. I'm here for our monthly legal roundtable with three great attorneys. I feel like I'm learning so much today. I just love this. It expands my universe in a good way. Today I'm joined by Bill Freivogel. He's an attorney and professor for the School of Journalism at Southern Illinois University, Carbondale. Also joined by Sarah Swadish, a labor and employment attorney who's in private practice at the law office of Sarah Swadish, and Kalila Jackson, a senior staff attorney with Equity Legal Services, Inc. Kalila, I want to mention the last time you were with us, you were working somewhere else, and we're excited about your new job. Can you just tell us a little bit about what you're doing?
Oh, yeah. Well, thank you for asking. Yeah. So at Equity Legal Services, we are a nonprofit legal services group. We provide free legal services to vulnerable communities. Specifically, we work with residents in what is formerly the city of Centerville, now Cahokia Heights. They've been facing decades-long battle of chronic flooding and raw sewage overflows that have just absolutely devastated their home. So we work closely with the community. They've created their own nonprofit. We have 2 cases pending in federal court. We represent over 30 individual families. The Department of Justice just entered a consent decree on behalf of the community last week, and we look forward to resuming that litigation.
You are fighting the good fight. I love it.
I like to think so.
And I'm having a flashback. I remember when I first met you, we were talking about these very people.
We're still talking about these very people.
You are still fighting. I love that.
Still fighting. Yeah.
That's great. Well, so on a less sort of important to life and death and people being able to live in healthy environments, let's talk about what's going on in Cottleville. This case is all about money. A developer is suing elected officials there. The firm Harmony Point says the electeds there blocked its apartment project and that costed $11 million. $1 million out of pocket, $10 million that they feel could have been their profits. Now, what's interesting here, this Harmony Point is suing these elected officials as individuals, not in their official capacities. They could end up personally liable for this. They're also seeking punitive damages. Sarah, could this get ugly?
It could get expensive, but I don't see the plaintiff Harmony Point winning.
Really?
I don't. I mean, they're entitled to bring a claim for substantive due process if the government is making decisions about their land or their use of their land, if it's arbitrary, if it's capricious, if there's a personal animus, if the government's saying, no, you can't use it for any purpose. They just haven't alleged facts even remotely near that. They've alleged that somebody campaigned on not turning the property into an apartment, and they haven't alleged any personal bias. They've alleged that they didn't want it, but a bad decision or just the wrong decision doesn't meet the threshold of a 1983 claim.
What if they had these elected officials on tape? This is not a fact. I'm getting into hypothetical land. And these officials are like, man, I just can't stand that developer. Let's sabotage this. Would this be a completely different?
That would be enough. Yeah,
okay.
That would be a personal animus. And it's not just that they don't allow them to use the land. It's they don't allow them to use the land for any purpose. So if the developer said, we want to put in a roller rink, and they said, no, but you can have a Walmart, then that would be fine. And we just haven't heard any animus against this developer other than we don't want Cottleville to grow. And having an apartment complex is a tax on a community. It's the wastewater, it's the school system. And so having an apartment complex is not necessarily ideal for a community. And if that's what the aldermen, city officials felt, then that's not oppressive. That's not a winning lawsuit.
So, Bill, I have covered many municipalities trying to decide whether to do projects or not. And I frequently hear them say, we have to be very careful here. We want to make sure that this developer can't end up suing us. Is that an overhyped threat based on Sarah's analysis here?
Well, I don't know if it is. I mean, I guess I sort of agree with Sarah that they'll probably lose, but the developer will probably lose. Excuse me. But the U.S. Supreme Court has been much more open to what are called takings cases. And they just had a pretty recent decision in which they said that a legislative decision to cancel some project that results in some party losing money, which is sort of the claim here, that can make that is something that you can file a lawsuit about and try to recoup the damages. You know, in the lower court, in this particular case, there was a whole Missouri court's history before it, and it involving the way in which the city canceled the development permit that had been granted, claiming that construction hadn't been started. And the Missouri court said that Cottleville was wrong in doing that, that the construction had started. And so there were a bunch of Missouri court decisions that actually the developer won. So we'll see. We'll see how it works out in federal court.
Yeah, so there is a path for developers. It's just not maybe wide enough for this case.
It might be hard.
Yeah, and the complaint goes through and says we were approved for this building permit, and we were approved for this zoning, and we were approved, and at the end they wouldn't let us move forward. Well, okay, but the law is the conduct has to shock the conscience. It has to be motivated by personal animus. It has to be oppressive and abusive. Like, they didn't allege any of that. So if there's this secret hidden tape, I would very much want to hear it.
Me too.
Just not being able to move forward it's not enough in my mind.
So we're talking about municipal politics. Here's another one. The city of St. Louis is dealing with a real mess due to the state takeover of police. And I'm not talking about the various expensive mandates or the big fight that's going on now where the mayor doesn't want to necessarily give police 7% raises and the police board does. I'm talking about apparently 70 different cases are in limbo. It's unclear if the state or the city bears liability. Kalila, here's a quote from Judge Henry Autry. This is something he said in court one day. It blows blows my mind that nobody considered this. It's a mess. It feels like this situation is just a morass. Like maybe the legislature didn't necessarily like line this this state takeover up in a way that was going to translate into a clear-cut legal action for all of these people wanting justice from the city.
I've appeared before Judge Autry, and he's a straight shooter, so I'm not surprised that he made that statement from the bench. But I think what you're seeing is, again, to harken back to something I said earlier, it's the state of political discourse. And so the legislature has been so reactive. And so it seems that this was poorly drafted legislation, and it's difficult but it got pushed through, right?
Yeah, it passed.
And now here we are trying to unring a bell, so to speak, or unwind that thread. And it's really difficult. It's proving to be problematic.
Bill, I know these lawsuits against police violation of civil rights, these are something that is close to your heart. What's your take on what's happening now with how the state takeover affects people who are bringing these lawsuits, trying to get justice?
Well, I mean, it's a real mess because I guess the state takeover put the state on the hook for paying damages, but there's a provision for an expense that the expense fund can be tapped up to $1 million. Well, I mean, come on.
This is the city of St. Louis. We're going to blow through that in a month.
There was a recent case. It was $28 million, and we've got and this one involving Luther Hall, the undercover agent who was beaten up by his fellow officers.
The worst case.
The worst case. Yeah. I mean, we're talking potentially a lot of money, and to say nothing about others that are out there, and so the idea that $1 million could satisfy that is ridiculous. Plus, then the notion that we're going to change this and make the Board of Police Commissioners responsible so that the city is responsible. Well, that probably violates the Hancock Amendment.
Because it would be adding all these costs.
A whole big additional cost onto a local government. And the Hancock Amendment, which was the darling of conservatives, would be violated.
Do you think if the state tries to do that move to put this on the Board of Police Commissioners, the city would have a good lawsuit challenging that just based on the Hancock Amendment?
I do.
Okay. Yeah,
I'm not
even
I'm
with these
the
courts.
only one who thinks that.
So this could get sorted out, but it sounds like this is not going to be sorted out anytime soon.
No. And, the 7% raise in the closed-door meeting on a snow day, maybe that's really great for the police, and I'm sure it is. But come on, but why is that not an open meeting?
That's a question I myself have asked, Bill. Thank you for raising that. I am curious, are we going to see some sort of litigation challenging that meeting? Because it was not an agenda item. So yeah, a lot of what's the phrase, Pandora's box seems to have been opened up by this state takeover of police. We've been talking about some terrible cases. Luther Hall, the undercover cop who was beaten by his colleagues, that's one of them. Here's another one. This one reached its resolution this past month in St. Louis County. 34-year-old Courtney Washington was having dinner with his friends at an Applebee's in St. John in North County when he just calmly walked out to his car, got a gun, walked back into the restaurant, and shot 3 people. 1 was killed. 2 others were badly injured. To this day, nobody knows why he did it. Like, he did not know these people. It doesn't appear that he was annoyed by these people. It appears it was completely random. So prosecutors, I think unsurprisingly, charged him with first-degree murder. The defense attorney said this is involuntary manslaughter because he inexplicably snapped. This is something he didn't plan to do. The jury ended up splitting the difference. They said this was second-degree murder. Bill, what do you think?
I know you see me as always on the side of the defendant, but I think it's first-degree murder. I mean, this gets into this whole really complicated issue of what constitutes the premeditation required for a first-degree verdict. Yeah. And it would be my opinion that for a guy to get up from his table, go out to his car, get his gun out of a bag, come back into the restaurant, shoot one person, then shoot another person, killing her, and then shoot a third person. I mean, premeditation had to occur to him at some point along the way.
Yeah, it does feel like that. This isn't just someone who snaps in one moment. Khalil, are you surprised that the jury did what it did?
Well, I was talking, to expound it a little bit, I was talking to my husband about this very subject, but not in the context of this case. We were talking about the Sonia Massey decision that just came, which also that officer was found guilty of second-degree murder when he had been charged with first-degree murder. So my husband, as a layperson, we were just kind of talking about how these things happen. And it's, Bill is right. It's this concept of, that, predetermined can be formed in an instant, right? And juries are having to wrestle with these really technical questions about is it a situation where did he go in intending to hurt someone? Did he go in intending to murder these people, or did something else happen? And as you said, it looks like they split. So I won't second guess the ruling of the jury. They were there. They saw the witnesses. They heard or saw the demeanor of the defendant. But this is tough, and I'm sure it was tough for the family.
And in the Sonia Massey case, can you remind us the facts on that one? This was again not a split second.
Just an absolute horror of a case. So Sonia Massey called for emergency services. She saw a prowler or a burglar outside of her home, so she called the police herself, and 2 officers reported to her home. They followed her inside, and immediately the interaction was very tense. And she had some boiling water that was on her stove, and the officers asked her to turn it off. So she approaches the boiling water, and she does appear to pick it up, and she starts to pour it into the sink. And the officer, Sean Grayson, starts giving her commands, and she began saying to him, she was saying, "I rebuke you in the name of Jesus." And she said it 3 times. And Officer Grayson pulls his service weapon, and he's pointing it at her. She's crouching down. And she still has she's crouching down. And at that point, the officer shot her, I believe, 3 times in her face, killing her. And even after she was shot and wounded mortally, Officer Grayson was saying that aid should not be rendered. So he was charged with first-degree murder. And the jury returned a decision of second-degree murder, and he received 20 years. The family, has expressed gratitude, but it's a controversial call.
Yeah. It's interesting because just to see a law enforcement officer be charged with something like that feels like something that is highly unusual, and yet then for the jury to come back with the lesser.
It's hard to get a conviction against a police officer. But that case in particular has a characteristic which is similar to a lot of other police brutality cases that go to court, which was this officer had been going from department to department to department, causing problems. Let's get rid of him. Causing problems. Let's get rid of him.
The bad apple who just keeps surfacing.
Yes. Wandering cop. Well,
that's a very dispiriting case. In our final minute and a half here, Bill, I'm going to end on a slightly happier note. You fought a legal battle. You were a plaintiff in a lawsuit that is leading to some good things. Can you give us the minute summary of this?
Well, now I get to criticize the Missouri Supreme Court.
Here we go. We come full circle.
No, the Missouri Supreme. So the state passed a law requiring the redaction of names in court documents.
All witnesses.
All witnesses, which including police officers involved, victims, and it was the most strict redaction law in the country, and it made it made the court decisions into gobbledygook. Somebody called us the state of no names justice, and so we wrote a bunch of stories about this, and broadcasters and press associations sued. A court overturned it as a violation of the First Amendment. The Missouri Supreme Court, which had been warned about this over and over again, then, after the decision, went back and revised and made changes in their procedures. One thing that, though, they left a big loophole in there, and that's why I'm going to be a little critical, and that is it says that it's up to the trial judge at his or her discretion.
Here we go.
Yeah.
Yeah, so there will still be redactions. Sarah, I'm going to give you 30 seconds.
So what I would say is this redaction law was passed by the legislature, and it's another example of them ramming something through without taking their time and thinking about it. Their session is from January to May, and they just ram things through, and they don't think of consequences. So this and the police board.
That's
and
right.
lawyers were so mad about this. Like, everyone practicing law realized this was bad. It still took Bill fighting in court to save lawyers from this. So, Bill, we are grateful for your service.
Thank you.
So, Bill Freivogel, thank you so much for joining us on today's Legal Roundtable.
Thanks.
And Sarah Swadesh of the Law Office of Sarah Swadesh, thank you.
You bet.
And Kalila Jackson, congrats again on the new job. Thanks for joining us today.
Thank you, Sarah.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.